Right, and there's language that says if, and I hate to use that word, but you've included it and you've defined it in there, so that's why I'm using that term. But it says if the person enters, attempts to enter, or is at any time found in the state after the person, then there are two subsections that explain like if they had been deported in the past, correct?
That is correct.
Okay, and so the part that says at any time, so if this person, this alien, this individual who was found at any time in the United States attempts, what does that mean, at any time found?
Well, I mean, it's the same, what it means is what it states there, and which is exactly word for word the same wording, because we didn't want to be in conflict with federal law. So it's the same wording that the federal government has used for decades.
But let me ask you this, because you talk about conflict, and I think this section is very broad and actually in conflict with federal law for several reasons. One, we discussed in a meeting that this section does not have the same affirmative defenses as are listed out for illegal entry, correct?
You're correct.
So if a person, let's say under this illegal reentry charge, even if they had been deported in the past for whatever reason and were found at any time, anywhere in Texas, that even if they are now a lawful permanent resident, if they have legal status, they can be charged now with this Class A misdemeanor of illegal reentry, correct?
I don't know that that's what it says.
Well, they have no defense. They have no defense, correct?
You asked me the question. Let me answer. It does define it as an alien, as that term is defined.
I'm sorry, Mr. Speaker, I can't hear the author.
Members, please take your conversations outside the rail.
Okay, so the premise of the charge is that someone is still have to be defined as an alien under our law, and is defined under federal law, and is defined in this SB4. And the definition, when you look to that, I believe it's under 1109, defines that as someone that is a non-citizen or a non-national. So someone that doesn't otherwise have the legal right to be there.
Well, that's not what alienage means, because you have specific affirmative defenses. So in the affirmative defenses in illegal entry, you specifically list people with a DACA, people who have a lawful presence in the United States. If they have this grant of federal authority, but they don't, even if the federal government grants an individual this specific lawful presence, your section regarding illegal reentry is conflicting with federal law because they can still be arrested under this state crime, correct?
And I don't believe it is. And I think, with all due fairness, I think you're completely misconstruing the statute, because all of that person would also have to be, when you look under subsection 1 and 2, would have to be someone that's been denied admission to or excluded, deported, or removed from the United States, or has departed from the United States while an order of exclusion, deportation, or removal is outstanding. So you would have to, again, meet each and every element of the offense beyond a reasonable doubt. And here, we're only talking about people, we're not, when you take that in a vacuum and just say, we're rounding up people that's at any time found to be in this state, that's a interpretation of that, because clearly it says, yes, but that person would have to have been denied admission, excluded, deported, removed previously.
Right, but what if, Representative Spiller, the person adjusts their status and has lawful status? If they are found at any time in Texas, they can be charged under illegal reentry. And that's my point. This is where this broad sweeping component that they can be found at any time in Texas, even if they adjusted their status, there's no defense for them under this provision of your bill.
Well,
so why didn't you include the affirmative defenses to illegal entry? Why didn't you include those affirmative defenses to illegal reentry?
Because 8 USC 1326 for reentry uses this definition. We tried not to stray from this federal statute. We've applied that here in SB4, and it used the same definitions. And so the facts are different. Under illegal entry, we're not talking about people that had previously been removed, deported, excluded. We're talking about something completely different here. And so the facts are, the elements of the offense for illegal reentry are therefore different than they are for illegal entry.
Is it your intent that, quote, being found at any time in the state is an attempt to indefinitely subject someone to punishment under this statute?
I'm sorry, I couldn't understand that question.
Is it your intent that if an individual is found at any time in the state, as defined by your statute, is that an attempt to indefinitely subject that person to punishment?
Well, as we've talked before, the range of punishment for this is, unless you get into an enhancements, is a Class A misdemeanor. That limitation period is 2 years. It's not indefinite. It's not 5 years, 10 years, 20 years. It's 2 years, and the statute, and it is limited to people that don't have the right to be here, that have already been ordered removed from our country.
So if anybody, to clarify, because I want to make sure we understand, so if somebody who is found in the state after the 2-year statute of limitations for the Class A has run, are they subject to this offense?
It depends on the facts. It depends on the circumstances. But what I'm saying is, it makes it sound like it's something similar to what you're describing is what Arizona did when, if you're here illegally, the show us your papers. If you're here illegally, we're going to round you up and we're going to prosecute you. That is not, I want to be very clear again, that Senate Bill 4, that is not the intent of Senate Bill 4. That is not what Senate Bill 4 says. And to take something out of context with illegal reentry and somehow assert or imply that is the standard, that is not the standard, because you can't apply that without applying the rest of the statute, which means that these folks have already been ordered out of our country. And this has been the law. The same thing has been the law for decades under federal law.
Let me ask you this. So a person who is brought into the United States as a child, they're deported with their family, they grow up in their home country, then that person marries a United States citizen. They go through the entire process to legally re-enter the United States as a permanent resident. They would be criminalized under the illegal re-entry statute.
I do not believe so. Do you want to know why?
Yes.
Let me tell you why. Because the first thing, if you look in the definition of illegal reentry, a person who is an alien, if that person has now obtained citizenship and gone through the correct port of entry and applied and gotten citizenship in the United States, regardless of what happened before, this statute does not apply to them.
Okay, let me ask you this. So the illegal re-entry offense, it contemplates a scheme where even if somebody has legal immigration status, they enter the United States lawfully, they could be criminally prosecuted and then required to be returned to a port of entry. So this appears to be substituting the state's judgment for the federal government in terms of who belongs in the country. How is this not immigration enforcement?
Well, you asked for a definition. That implies that we somehow have a definition of legal immigration status, and that is not what this bill talks about. It tracks the language of existing federal statutes and talks about in terms of if someone is an alien. So to the extent that if someone has legal immigration status, if they're not deemed to be an alien, then no, it would not apply.
Okay, there are situations where federal government sometimes allows a person to legally come back into the United States after a deportation. It's called a permission to reapply for admission in the United States after deportation or removal. If that person is granted permission to come in legally, this section says that you can't come back even though the feds say you can. So under SB4, as I mentioned, there's no affirmative defense, and this appears to be substituting state judgment again. So can you tell us how that's not immigration enforcement?
Well, I'm not aware of any claim that's been made at the federal level against 8 U.S.C. 1326 that says that this is illegal or it's improper. And so therefore, the same thing, just like it's upheld and it's valid law and has been for decades, the same should apply here. They are exactly the same elements.
Okay, let me ask you this. You heard Attorney General Ken Paxton in the past has said that he hopes that the Supreme Court rules differently from the Arizona versus United States case, which has already determined that states cannot enforce immigration, right? So you've heard the AG Paxton say that, right?
I'm not advised.
Or do you know that he made that stance or statement in the past?
I don't know that.
But you're working with his office on this bill, correct?
We've communicated with many parties on the structure and implementation of this bill. Yes.
Yes or no? Did you work with Attorney General Ken Paxton's office on this legislation?
I just said yes.
Thank you. Do you hope that the Supreme Court will overturn Arizona versus United States?
No, I'm
You
not
don't hope-
asking for that. This is not that. I mean, people have asked me that. Are you trying to overturn Arizona versus U.S.? And my answer to that is no. Whether Arizona versus U.S. was properly rendered or not is irrelevant because we have steered completely clear of what Arizona did, Senate Bill 1070, when they passed that in 2010, and the issues and problems that they had in the Arizona case.